Good morning friends, Sat Sri Akal, Adab, Namaskar. Now this is again the same series of the TPA Act. Whether its applicability as per Rule 10 is applicable within the cantonments. Now here we'll read some definitions now, which are generally written in a sale deeds. I'll read the definition of immovable property. As per TPA Act and the Journal Clauses Act, does not define the same correctly. So what was sold to us in various sale deeds, we need to understand. Now section 3 of the TPA Act states the interpretation clause. In this act, unless there is something repugnant in the subject or context, immovable property does not include standing timber, growing crops or grass. Instrument means a non-testimoniary instrument. Attested in relation to an instrument means and shall he deemed always to have been attested by two or more witnesses, each of whom has the exequent sign affix his mark to the instrument or has seen some other person sign the instrument in the presence and by the directions of the exequent, or has received from the exequent a personal acknowledgement of his signature or mark. So this is what it is trying to mean. Now registered. Why this particular testification of an instrument was registered? Means registered under subsection of various 1952 Part C states, its application, adaptations and the territories. Now if we read the Indian Registration Act 1902, law for the time in force regulating the registration of documents, attached to the earth means rooted in the earth, as in the case of trees and shrubs, embedded in the earth, as in the case of walls or buildings, attached to what is so embedded for the permanent beneficial enjoyment of that to which it is attached. So, registered meant this. Actionable claim under section Act 2 of 1900 means a claim to any debt other than a debt secured by mortgage of immovable property or by hypothecation or pledge of the movable property or to any beneficial interest in movable property not in the possession either actually or constructive of the claimant, which the civil court would recognize as affording grounds for relief, whether such debt or beneficial interest be exent, accruing, conditional and contingent. So a person is said to have notice of a fact when he actually knows that fact or when but for willful abstention for an inquiry or search which he ought to have made, or gross negligence he would have known it. So, what I'm trying to actually come up is the Registration Act, it came up in 1877, 1908. So, you have all these sections which talk of the sub-registrars, the registrars, the TPA Act talks of these words. So, what are we actually trying to, where can we get this? So, the interpretation of the immovable property is neither clear nor complete. It speaks what is excluded from it, but it does not speak what is included. If an act in the meaning of any word is not given clearly, the meaning of that word may be found in the Journal Clauses Act. Now it defines as per section 22, immovable property shall include land, benefits to arise out of land, and things attached to the earth or permanently fastened to anything attached to the earth. So in both these acts, they have not been able to define the expression of immovable correctly. Would it mean this way? So land means surface of the earth, including everything upon the surface of land, under the surface of land, and also above the surface of the land. Anything on land so long it is not removed from there shall be a part of the land and as such immovable property. Thus, solid or mud deposit or water collected in a pit or accumulated in a pond or a lake is immovable property because the water is part and parcel of the surface of earth. Water flowing gives an expression, it is movable property, but that is not true as it flows on the surface of the earth. Similarly, everything under the earth like coal, gold mine is immovable property. Moreover, not only the things on the land and under the land are immovable property, but the space which is above the land is also part of land and is immovable property. So, we need to look up all this in a very close manner. We need to get our advocates working in this direction also. That what is the TP Act, what is the General Clauses Act saying on immovable properties? So, then only can we bring in something. Otherwise, every time when we talk of a sale deed, we read some particular words in it, we are unable to define them. Once we plead these, then somewhere our cases, then the travesty which has been happening for the last 100 years, I would say. See, during the British regime, I will not speak because we were slaves. So, I don't bent upon the judiciary. But later on, what happened is, our advocates only educated on the judgments which were against us during those periods, instead of interpreting the law laid by the Britishers in a very, decimal kind of a manner, breaking up it. So now I'll read the General Clauses Act 1897, the definition here. In this Act and in all central acts and regulations made after the commencement of this Act, unless there is anything repugnant. Now, what does it speak? What is British India? It shall mean as respect the period before the commencement of Part 3 of the Government of India Act 1935. All territories and places within His Majesty's dominion which were for the time being governed by His Majesty through the Governor General of India or through any governor or officer subordinate to the Governor General of India, and as respect any period after that date and before the date of the establishment of the Dominion of India, means all territories for the time being comprised with the Governor's province and the Chief Commissioner's province, except that a reference of British India in an Indian law passed or made before the commencement of Part 3 of the Government of India Act shall include a reference is given to Berar estate either. So, British India meant the governing of the Indian domain by the Queen or by the Majesty. Were they the landowners? That is a question we need to. Now, what is the definition of British possession? It shall mean any part of Her Majesty dominions exclusive of the United Kingdom, and where parts of those dominions are under both a central and a local legislature. All parts under the central legislature shall, for the purpose of this definition, be deemed to be one in British possession. So, friends, we need to really study all this. Now, section 26 calls immovable property, which I read earlier, shall include land, benefit to rise out of land, and things attached to earth or permanently fastened to the earth, attached to the earth. Now, what does local authority under section 31 means? Shall mean a municipal committee, a district board, body of port commissioners or other authorities legally entitled to or entrusted by the government with the control or management of municipal and local funds. We can jumble out this. What are cantonment boards? What is the local self-government imbibed in 1924 in the 1880 Act of the Cantonment Act? That we are a local authority or a local self-government. So we can really work hard on this. So I think now with these videos, and if people have watched me in a series, they will understand that yes, TP Act was applicable on cantonments, and since the British Governor General orders from 1798, everything was in place. So friends, just remember, we were old Qurans, never converted into new Qurans by the Britishers, from 1798 orders of the Governor General. That's all. Thank you. Good day.